Welcome back to Canadian Justice, where we are discussing the right to a speedy trial and the cases of Jordan and Hanan. And Saman Wickramasinghe was the lawyer in the recent Supreme Court case of R.V. Hanan. Now, one of the things I wanted to ask you both about is, how often are you actually seeing this in your practice? Kabir, I'll start with you. How common are these delays that go so long that they are triggering that 18 or 30-month hard ceiling that was established in Jordan?
Typically, in my practice, I don't see it that often. We try as hard as we can to ensure that our cases are moved through the system as quickly and as efficiently as
But the
possible.
thing is, sometimes it's the Crown delay, right? That's the whole problem.
It is.
If it's your delay, it gets subtracted.
Absolutely. And what I am seeing, though, after COVID is that a lot of the Crowns were relying on COVID to justify a lot of delays that were not warranted. So now what the courts are doing is they're looking back and they're analyzing the delays caused by COVID and actually taking a deeper look to determine whether or not were they actually caused by COVID or was it actually caused by a culture of complacency with the Crown and the court. And so I'm seeing now it's more moving towards that direction. We're getting a lot more decisions now that are in favor of the defense.
Yeah, that's a great point, because the Jordan ceiling, the 18 and 30-month ceiling for the right to a speedy trial, that's a presumptive ceiling. But the Crown could rebut that presumption. And they are arguing, and as you've said, that COVID has caused some of that backlog. Saman, on the issue of when COVID actually qualifies as causing this delay, how successful are those arguments? What are you seeing?
So I've not had to deal with a COVID-related 11B argument in a case, and that's because COVID did play, was a justifiable type of delay. I mean, I think that it was an exceptional circumstance that nobody had any control over, and over time the court had worked, I think, very quickly, or actually it wasn't very quickly, but had ultimately achieved, technological changes that allowed cases to happen much more quickly, even at the tail end of COVID. So I haven't argued a case that was COVID related in the 11, taking into account 11B. But I would add to Kabir's answer that, I really do think that Jordan is working. We are seeing cases being processed a lot quicker because the burden is on everybody, including the defense, to get these cases to trial as quickly as possible or resolved as quickly as possible. But in my practice, maybe 1 out of 20 cases might have some delay concerns. That doesn't necessarily mean that delay is unjustifiable, but where there might be some delay concerns.
Yeah, let me follow up on that with Kabir, because this rule changed in 2016. Kabir, have you seen the courts and the prosecutors respond to Jordan to actually process things more quickly? Has it actually improved the situation? We've got about a minute left.
I'll say yes and no. Back under the old framework, it was a possibility that, sometimes 12 months could be considered an unreasonable delay. Now, some Crowns and the court sometimes see 18 months as, I have 18 months to prosecute this case, not I need to prosecute it as fast as possible. And so in that sense, it's kind of increased delays a little bit, but people are more on the ball now in terms of knowing that 18 months, the case is going to be totally gone. And there are situations in which under 18 months, the defense can still argue that the delay has been unreasonable in certain circumstances. So there is kind of a safety net there as well.
Well, Saman, Kabir, I want to thank you both so much for coming on today. It's a fascinating topic. It's not a technicality, as you both expressed so clearly. It's an important part of our Constitution. And I'm so grateful that you both came on today to explain the role that it plays in the justice system.